Thank you for the invitation. It's not the first time that I present here at the university at the American Legal Thought conference. I think it was like 2 years ago that it was the first time. 2 or 3 years ago, that was the first time that I presented here, that I participated in the conference. So thank you once more for trusting me with my presentation. And today I'm going to talk about the evolution of views of statutory interpretation in the US since the New Deal era. And this new deal actually will be the most the period that I will focus on principally. So let me just briefly divide the areas of interpretation. So we all know that in the common law countries we can divide into 3 areas of interpretation. So it's first one constitutional, then statutory interpretation, called common law. And the thing is that with statutory interpretation, the importance of statutory interpretation depends on the activity of the legislature. So the more active the legislature is, so the more issues, the more matters are regulated by statutes, and then the more the effects of the importance of statutory interpretation increases. So Calabresi already in 81 said that in America there's the statutory interpretation is the primary source of law. So the statutes are the primary source of law, and unlike before when there was the common law that was primary source of law. That's why the statutory interpretation has increased its importance. And to briefly note what happened before the New Deal era, so at the beginning in the first 30 years or so of the 20th century, we could distinguish, I'd say, like three movements. So the first one was formalist, and the one that was well, of course, as we know from Brian Damanaha's accounts, we all know that the divisions were not crystal clear, but so they have a lot of in common, but still we divide it into 3 areas. So it is formalists that are more inclined towards mechanical jurisprudence and deductive methods, then pragmatists and sociological jurisprudence, and legal realists. And then, of course, the New Deal, what to say, we all know that we all know what is the Great Depression, and resulting from the Great Depression, there was an initiative to confront the results of the Great Depression, just to, and this New Deal, let's say, there were kind of like 2 New Deals. We divided into 2 phases. So there was the first New Deal and the second New Deal. Actually, so it was from 33 to 39. There was a series of reforms of programs that were destined, that were tailor-made to fight the effects and the results of the Great Depression. So there was 3 R's basically. So it's relief to help people need recovery of the economy, and reform to prevent this kind of economic declines in the future. And actually, what is important for statutory interpretation, that there was a kind of consensus. There is the consensus that actually we have not seen since that time. So there was this consensus already was starting to flourish, to take into effect before the World War. So there was 3 principal ideas that law is a policy, so law is a kind of instrument to promote some social policies. And then there was kind of the the impact of institutional competence. So there was a lot of attention paid to institutions, and then so there was just this presumption that if our decisions on policies are made by competent institutions, then there will be a good decision. So kind of this, let's say, this rationalist view of law, and then that principle, and then democratic openness is the basis of legal legitimacy. And there are like few principle texts, legal texts that have really shaped this kind of consensus, but not really shaped maybe, but they were just, let's say, ideal examples of what the consensus looked like. So this, and I will like to concentrate on the first one, so on Hart's and Sachs' legal process, because it's the most comprehensive one, and the one that's really shaped views on statutory interpretation for the long time. Actual legal process, actually, there was it's legal text, but that has never been published. Actually, it has never been published by authors. It was published by in 1990s, but it was, of course, authors were long dead, and there was William Eskridge and Philip Fricke that prepared the legal process materials. Actually, so the legal process by Hart and Sachs, there were materials. There were materials prepared for education purposes at the Harvard Law School, and that was, but still they were dispersed. They were widely circulating in a lot of legal academia and a lot of universities in the US. And there are three principal intellectual foundations of the legal process. So that's the organic rationalism, so that legal decisions are neither rule-bound and deductive, as the formalists thought, nor intuitional and inductive, as some of the realists thought, but instead that's when we take a decision, when we make a decision, we express the coherent reason in the fabric of law. So that's the one base. Then the second is the New Deal's administrative state. So that's really important, that the agencies were the institutions that kind of developed the statutory schemes. So they were the ones. A lot of emphasis was put on not on the fact that the law is made for citizens, so the addressees of legal acts are citizens, but they are that organs, that administrative state is an addressee of legal acts as well. So that's the importance of administration, and that was put in front. And there was this reaction to totalitarianism. So that's we could say that this democratic openness that we saw on the last slide was very important. To sum it up, so what's the legal process view on legal interpretation is that statutes should be interpreted to carry out their objective purposes over time. So objective, which means that objective, we need to comprehend it as a contrary to the subjective view of the legislature. So that's why agencies were tasked with developing statutory schemes over time. And then procedures, that if we have good procedures, if we have good open rational procedures, and they could, through these procedures, we could identify the purposes selected by the legislature without actually substantively evaluating those purposes. So that's kind of this procedures are open, are transparent in kind of way, and do not touch upon substantive matters. And these procedures are critical to law's legitimacy. So that's kind of response to the after the times of legal realists, when we all know that legal realism kind of tarnished a bit the ideal of rule of law, at least in the public view. So we could say that legal process is kind of deliberative, pluralist, and of course open to dynamic interpretation. So the legal process attention summed up the attention of really the majority of the legal academia. But actually this consensus that lasted for about 20 years, when let's say not the final but the mature version of the legal process came out, it was in the 50s. That consensus, that very consensus, started to fade away, and it started already with the decision by the Warren Court. And actually, I said that I would concentrate on statutory interpretation, and actually the legal process by Hart and Sachs, were concentrating. They were concentrating on statutory interpretation, but the problems with the legal process actually came to the fore at the constitutional interpretation level, and by the decision of the Warren Court. Because the collapse of the consensus was actually linked with the civil rights movement that started in the 50s, and that unraveled the intellectual substantive consensus achieved during World War II, and therefore undermined important conceptual foundations of the legal process. So I said that there was kind of assumption, and there was kind of idea that if we have good procedures and good and competent institutions that decide upon the legal issues, that we will have good decisions. But the legal process thought have not put a lot of attention into substantive fairness. And what came out in through the civil rights movement was that this consensus kind of can petrify the status quo, which obviously, and that within the status quo, a lot of groups of subjects, of legal subjects, were out of that status quo. So they actually were discriminated. And of course they weren't, and they didn't have the same rights as the ones as this main core groups in society. So we could say that from the left, they started to be, so there was the movement that came into that developed into critical legal studies and all its relatives. And from the right, it was the public choice theory that really undermined the assumptions of the legal process. And so further developments, and and I will just finish because my time is running out. And the time, so in the 80s, so there was the period of the 60s and 70s was the kind of really the judicial activism, and the academia started to perceive that the assumptions of the legal process were not really correct, and especially there was this substantive fairness component that was missing. And so there was a revival of interest in the 90s, and so one of the areas of this, one of the areas was the debate between static statutory interpretation, mostly comprehended as intentionalist interpretation, so as the intent of the legislature, versus dynamic statutory interpretation that was championed mostly by William Maciej Jr. or Philip Fricke. And right now we could say, and of course there was, to curb this judicial activism, there was the movement of the new textualism. So in order to, so that we associate the most with such names as Justice Scalia, Justice Gorsuch as well. So there was just this movement to develop the canons of construction that could curb, that could restrict the judicial activism. And yeah, thank you for your attention. Of course, there are a lot of issues that I have just touched upon and not developed much, but I'm open for all the questions that you may have. And in the case of longer questions, here is my email that you can always reach. So thank you for your attention, and I'm looking forward for your questions.